This week, we're going to move into talking about title, the passing of title for the sale of goods, and also the closing of the sale. So once goods have reached a buyer, what can the buyer do or not do that signals things like accepting the goods, or if the buyer feels like the goods are not conforming with the contract, how can the buyer effectively reject those goods? We'll start today with title. You'll recall that the warranty of title and the warranty against infringement were the final pieces of the warranty provisions in Article 2, Part 3. And the warranty of title is the only one that we didn't see in 2316, where there was really a clear way to exclude or modify it. So while it is technically possible, and your book talks about some examples like sheriff sales where that passing the warranty of title is legally waived, almost every sale carries with it this warranty that the title is supposed to be good, its transfer is rightful, that the goods are being delivered free of any security interests, those sorts of things. So that's what we see in Article 2312. What we're going to focus most of our time on in this lecture is the transfer of title. So Part 4 of Article 2 that talks about passing title. It also has a little bit to say about the rights of creditors as well as the power of entrustment and what somebody who has been entrusted goods can do with them. We will really focus the most today on what we see in 2403, the power to transfer title, good faith purchase of goods, and entrustment. But just a quick highlight of 2401, that is just saying the situations in which title is said to have passed from the seller to the buyer. We'll talk a little bit more about those situations, but that's important because, as we were talking about last week, who carries the risk of damage to the goods also is impacted by who has the title to those goods at any point in time. The default being that once the seller's delivery obligations are complete, the title is transferred, though we'll talk a little bit more about some common documentation and a few sort of wrinkles in that process. For 2402, this is the importance of Article 9 of the UCC. If you are a creditor, you need to secure your interest. That's critically important. And 2402 says that, if you're not securing your interest, creditor, then your rights are going to fall way behind other people's rights. So you need to make sure that you're following Article 9 on securing your interest in goods. And then 2403 that we're going to talk about today in terms of transferring title and the type of title that you are receiving. So title is something that you might recall from property law in the past, and as we'll talk about a little bit in the future, still in the present. This used to mean an actual document that you passed along with the goods themselves. You're probably most familiar with this in the context of car titles, for example. Title, simply put, is your right ownership in a thing. So it's an ownership right. If you own it, you possess it and you can use it or dispose of it. Title and possession, as we'll see in our discussion today, aren't exactly the same thing, but you think of it as I control this good. I have the right to say what happens to it. From a sale of goods perspective, we are concerned with whether the seller actually owns or possesses the goods and the title to the goods that she's selling to a buyer. Most of the issues that we're going to talk about today are concerned with the chain of possession. Did each person in the chain have title so that she could pass it along to the next person in the chain, down the chain of possession? If not, and if somebody in that chain didn't have title, right, enabling them to pass it down, can the goods be taken from someone who is currently in possession of the goods and returned to the last person who had valid title? Seller has to have title in order to legally sell goods. She can't disclaim the title along with other implied warranties in some sort of effort to fence stolen goods with no contractual penalties, or just to protect herself if she's maybe not too sure where the goods that she's dealing in come from. But 23122 does allow the seller to use, quote, specific language, end quote, to notify the buyer that he does not have title or has limited title in some way. The trickier cases, and the one that we're going to talk about today, are cases where goods are not outright stolen and then fenced. Because in those cases, the last-in-time buyer has to give the goods back to the original owner and bear the risk of loss. But there are a few scenarios that the law deems to carry voidable title, not void, voidable. And so the law says that in these cases, the goods may be passed with a valid title attaching to them. And these are the two 403 scenarios we're going to talk about today. One situation, we'll look at a case that is whether if the goods have essentially been procured by means of fraud, but there was actually intention to transfer the goods. In those situations, the downstream, when I say downstream, I mean down the chain of title, the down chain purchaser may still take the goods with valid title, meaning they don't have to give the goods back up to the original owner. The other situation that we're going to look at is the situation of entrustment. So a situation where you bring a good to a merchant, not, your book points out, sort of a pawn shop, but an actual merchant who deals in goods of that kind, perhaps to resell it for you as your agent, perhaps to hold it as a bailee. And if that person is a merchant of a good of that kind and sells your good to a buyer in the ordinary course, as opposed to some other sort of transaction where it's not a purchase, right? So conveying the goods to somebody else to settle up a debt or something like that. But just a buyer in the ordinary course, unsuspecting, comes in to that merchant, purchases the goods that happen to be your goods, right? Then the recipient is said to have title to those goods. And here, in that situation, I think it probably makes sense to you conceptually why that rule, at least to the framers of the UCC, seemed fair, because in those situations you have essentially an unsuspecting customer who's acting as they ordinarily would, buying from somebody who seems reputable because they deal in goods of that kind. And so in those scenarios, the UCC says the risk doesn't fall to the ultimate purchaser. You'll recall that over the last few weeks I've used this term bailee a few times, so I just wanted to give us a little bit more background on what is a bailee. So somebody who is a bailee has possession, custody of goods without the transfer of ownership. Right? The goods are temporarily in their possession for some reason, but the bailee is not the owner. The bailee does not have the ownership and title to those goods, and so the bailee doesn't get to choose how the goods are used. There's lots of bailee relationships that we enter into in our everyday lives. So for instance, if you were to leave your car with a valet, when you give them the keys, you weren't transferring the title to your car to them, but they do have custody of your car for a certain period of time. Similarly, when you take your car into the mechanic, right, they have temporary custody of your goods, but they are not the owner. Other situations where you see a bailee relationship with respect to goods might be if somebody is repairing some other good you might have, a watch, restoring a painting, that sort of thing. So let's talk about our complications that we see with title. We know that seller cannot disclaim, generally speaking, the warranty of a valid title. So what happens if the purported seller who is in possession of the goods tricked the original owner to get those goods? Now, if somebody does that, but tricks the original owner, but the actual transfer was voluntary and intentional on the original owner's part, then what ends up happening is the trickster gets voidable title. So that person, we'll call them the trickster for this scenario, can transfer title to a good faith purchaser for value, even if he got the goods by deception about things like his identity, by dropping a bad check, not paying for the goods in some fashion, or other fraud, including, as we'll discuss in our case for today, if the delivery was procured through fraud punishable as larcenous under the criminal law. So certain types of behavior that might be viewed as larcenous or theft, those could still be a situation that would apply to 24031, assuming that the transfer by the original owner was intentional, was voluntary. So, it's the distinction between sneaking into somebody's garage and stealing their car versus, as we see in our case, acquiring the car through means of a fake check. And then we have our entrustment provisions that we'll talk about, and this is where a merchant dealing in goods of the kind is entrusted with property by the original owner, and that person has the power to transfer goods to a buyer in the ordinary course of business with valid title. We're going to work through these to a large degree in our discussion problems during our class discussion. So our first case today, West v. Roberts, is a nice illustration of this idea of chain of title. So West, the original owner, sold his Corvette to a guy that gave him a phony cashier's check and then skips town. The car eventually was bought by Tammy Roberts' brother, and then by Tammy Roberts from her brother. Right, so we have our plaintiff, the original owner, West, who sells it to a Robert Wilson, presumably not the fraudster's real name, who eventually it gets passed down to Tammy's brother and then to Tammy. The trial court applied 2403 and said Roberts was the rightful owner. The appellate court upholds this decision, saying it's not theft for at least purposes of this Colorado statute if the owner was aware of the taking and intended to part company with his car. And after a good amount of statutory analysis, the court goes on to say that in deciding which statute takes precedent, the criminal code that Plaintiff West is trying to apply and the commercial code that the defendant Roberts is trying to apply, that they think that the commercial code should take precedence in this situation. Here, West is trying to get his car back. He asks the police to check the vehicle identification number. The VIN was registered by Tammy Roberts, so West knows now that Roberts has the car. The question was, did she have rightful title when she herself purchased the vehicle? Does the court say, first of all, whether Robert Wilson, our original purchaser, stole the car? And that, yeah, he did. If you look at the Colorado criminal code that applies here, a deception by fraud could amount to theft of the vehicle. Right. And so West is trying to claim here that 2403 should not apply. And he does it through, I would say, sort of a sleight of hand misdirection kind of argument by saying, well, there wasn't entrustment here, so 2403 should not apply. And the court kind of redirects his attention and says, yes, West, but you're looking at 2403 about entrustment, and really what applies here quite on its face is 2403(1). And the court goes into a lengthy analysis of UCC 2403. So what kind of title did Robert Wilson, our original purchaser, obtain that he could then pass down the chain of ownership? And what I think is really nice as you read through this decision is you see how courts will do a statutory interpretation analysis. Here they're trying to compare the criminal code with the commercial code, and they point out to us, and this is one of the real benefits of having a uniform commercial code, that, as they say on page 300, when a Colorado statute is patterned after a model code, this court may draw upon outside authority in interpreting the provision. So at least in Colorado, when you're dealing with a UCC question, you can look at how other jurisdictions have also dealt with that section of the code. So it really opens up your scope for potential precedent if the court can do that. And amongst other things, they look to Kentucky shorthand for good faith purchaser for value, to get a sense of it, what that could mean. One who takes by purchase getting sufficient consideration to support a simple contract, one who is honest in the transaction of the purchase. So they're looking at other jurisdictions to see how they're working with the commercial code. What about his argument, West's argument, that the car was stolen? Well, the court essentially says that's too bad because you voluntarily entered into the transaction. Right? While Tammy Roberts at the bottom of the chain, she was ultimately a good faith purchaser for value because she gave sufficient consideration, and she, at least the court believes, was honest in her not knowing that the goods themselves were stolen. Now, it's interesting also that when the court is doing its statutory analysis of 2403, they point out that their analysis that really in this situation our plaintiff is out of luck is actually strengthened because it seems as though Colorado has created a carve out from the situations where a purchaser can receive a transferable title, essentially voidable title, even though they're giving a bad check or something like that. And so I want you to take a second and see if you remember what the Colorado special provision was for. Sort of analogous to a Corvette, horsepower, not really. Cattle. Colorado had a provision about cattle that said that for livestock, you needed to actually have the money in hand. And so if you paid with, a check that didn't clear or something like that, then you could roll back that particular transaction. Right? UCC says, let Roberts keep her car. Stolen property statute, the court acknowledges, says, give it back. Okay, so now the court has to balance these two and decide which takes precedent. And so they give a number of interpretive rules here, including that if you, first of all, you try to read statutes consistently, you try to reconcile them. If you can't reconcile them, then you look at the nearest in time, the most recent one, and that also more specific provisions prevail over more general provisions. And I think if you look at 2403, you'll agree it's pretty specific about these situations that are covered, like the identity misrepresentation, like bad checks. So looking at those interpretive rules, the court says UCC should control in this situation. It abrogates, the term of art, it abrogates the Colorado Criminal Code. Our next case deals with the entrustment provisions in UCC 403. So in this case, we have our parties, Great American, who's actually the insurance company for the business that originally owned the goods in question, a bunch of electronic networking equipment, suing Next Day Network, who was the ultimate, well, at least an ultimate purchaser of equipment that had been stolen from this business. So let's think about what the chain of title is here. We have our plaintiff, the insurance company for Vectren, the business that was stolen from. We have Brian Crow, who's the employee of that business, who was apparently siphoning off their IT equipment and selling it to companies like Next Day Network, who bought it online through an online auction from Brian Crow. And Next Day Network, and this I think is what really gets them in trouble with the court, even after they receive notice that these were potentially stolen goods, Next Day still wants to sell this equipment to other buyers. So Next Day is being sued for conversion, aiding and abetting conversion, civil conspiracy. And the defendant's defense is essentially one of entrustment. This is a situation that should fall within entrustment under the UCC. Maryland's court says for entrustment, there has to be these factors. This is on page 308. There must be an entrustment of goods. That entrustment must be made to a merchant who deals in goods of that kind. Transfer must be to a buyer in the ordinary course of business who purchases in good faith without knowledge that the sale violates ownership rights. Now, intriguingly, I think, Next Day isn't arguing that they were a buyer in good faith, which is what you think they would argue under 24031. If you look at that provision, a person with voidable title has the power to transfer a good title to a good faith purchaser for value. And I assume that they're not making that argument because it's pretty clear that these were stolen goods. So not ones that had been voluntarily transferred by the company. So then, if that's sort of ruled out, they try to figure out, well, how do we seem to make this fall under 2403? And I think their argument must be something akin to, well, we already have purchasers who intend to purchase from us, and so maybe we can try to say something like, it's as though these goods were being entrusted to us and now we have agreed to sell them to people downstream. It's a little unclear to me, frankly, how they thought this argument was going to go. Here defendants argue the entrustment provision applies because Crow entrusted the stolen IT equipment to Next Day. So they're like, well, it was voluntarily transferred to us by this veteran employee. Next Day is a merchant who deals in goods of the kind, and Next Day was a buyer in the ordinary course of business. And the court says, no way. First, you need to have 3 separate parties for entrustment. The original owner, the merchant that they entrust the goods to, and then the buyer. As it only applies when a rightful owner attempts to sue a buyer after the buyer purchases goods from the merchant. And here, Next Day, you seem to be arguing that you're both the merchant being entrusted with the goods and the person buying the goods. That's not going to work. Second, if you are claiming to be the merchant in this scenario, a merchant who turns around and sells the goods knowing that they aren't his is liable for conversion. So if you're claiming what you're claiming, you could be sued for conversion. Okay. And finally, you need to have at least voidable title. Okay. In an entrustment scenario, the owner has to voluntarily transfer the goods to the person that is the entity that's being entrusted with the goods. And if the goods are stolen, then it's not voidable title, it's just void title. And so nobody seems to be alleging here that Crow somehow misled Vectren into giving him the goods in the first place. So because we don't have that voluntary transfer, 24031 is not a good fit. And because we don't have the sort of 3 steps of original owner, merchant to whom the goods are entrusted, and another buyer on the end, we don't have a good fit for entrustment under 2403. I didn't assign the following chapter on leased goods, but I do want to just give you a little bit of background by way of comparison. So title doesn't pass for leased goods, right? So title isn't the right concept here when we're talking about leased goods, because the important thing is the lessor retains the ownership interest, right? Retains the title in the goods. So what the provisions in Article 2A talk about is a quiet possession of the goods. Right? And if the goods are leased by a merchant, then the lessee receives them free of third-party infringement claims. So you get something a little like some of the warranty of title, but it's just a right to quietly possess, so not have your right of possession challenged by other parties. So the chain of ownership is similar in 2A to what we see in Article 2, with the exception that the final person in the chain who ends up with the goods doesn't own the final good, right? But instead steps into the original lessee's shoes, and that final person in the chain would be subject to the terms of the original lease. Right? So as I illustrate on the side of this slide, the original lessor leases to your bad actor. Your bad actor lessee sells the goods to Blameless. Now, bad actor doesn't have the right to sell the goods. Remember, they just have the right to quietly possess them. Original lessor owner still owns those goods. So now we have this person at the bottom of the chain who's paid money to bad actor. Well, that's something that Blameless and bad actor have to settle out. But Blameless can now be subject to the original lease terms, step into the shoes of bad actor. Now the caveat being that there is an equivalent entrustment provision in Article 2A 305. So if bad actor also happens to be a merchant with respect to goods of the kind, and then Blameless comes in and buys those goods, then it's analogous to the entrustment provisions that we were talking about for UCC 24033. Okay. I will see you all for our discussion about the problems in Assignment 16.